Hey guys, it's Kathy. I hope you're doing well. And I really, really, really hope that you hear something today. I really hope that when I press play, there's sound and a lot of sound, but you never know. If not, I'll just close the stream and go back to the old way once again. I didn't have a chance to test it because I just got done 2 minutes ago. So, oh my, what did I miss? Holy cow, guys. All right, who's first? Boom, first. All right. I heard that I saw in the Discord that Juan did good today in Harris County, but I didn't get him. I did not get him, so we're not going to see him today. Okay. I don't hear anybody right now saying there's no sound, but this isn't where their problem was yesterday. It was when I played a clip. Remember? Oh wait, there. You got to. I thought it went away automatically. Now I have to do more work. I have to click it and then click it. Let's see. Hey, Kelly. Oops. Oh, it goes fast. And if I don't click it right, it'll just click the next comment. Oh, again. Okay. That's all right. I have an idea. Haley, see? Oh, wow. J Fire's here already? Am I late? What time is it? All right, guys, let's start the first clip and see if you can hear anything. That would be nice. Oh, man, the first clip is called Stop Talking. Okay, I'll stop talking.
Is the moderator back? Sure, probably. So we need to stop talking. Okay.
Okay, we'll get on the record in People versus Kalina. I'll get your complete name, just 1 minute. Lorraine Doris Hensley, case number 24006364. And Ms. Hensley, is that your true and complete name?
Yes, Your Honor, birthday is correct also.
Okay, thank you. And Mr. Ambrosio is here for the Public Defender's Office. And Ms. Hensley, do you have the money to hire an attorney at this time? Yeah. Okay. I'll appoint the Public Defender's Office, Mr. Yeoman, for the people. This matter is on for arraignment, ND waive formal reading and Rainer advisement of rights. Mr. Ambrosio?
Yes, Your Honor.
And you're prepared to enter not guilty, please, on behalf of Ms. Hensley?
Yes, Your Honor.
Okay. And counselors, you wish to be heard regarding custody status, please?
We do, Your Honor.
Yes.
Well, Your Honor, I was her attorney in the previous case. We just entered a resolution with the people on the case. The contraband that was found in her clothing that was in the jail lockup. So she didn't bring anything in. It was already in possession, but I believe law enforcement didn't find it thoroughly the first time. So we are asking the court to consider releasing her on her own cognizance. One, because she did just own up and take responsibility to her last case. And two, there was no new crime committed here. Whatever she came into jail with is what she came into jail with. The police didn't find it until she was being released, and then the police found it. And now there's a new charge right after she's already settled a case. So while we don't expect the court to dismiss this case outright, we are asking the court to at least consider releasing her on recognizance in order to honor the spirit of the bargain with the people, in which she took responsibility for what she was arrested for in the first place and was set to be released.
Now, so she was getting released from her sentence?
Yes.
On the one case, and then they found, where was it that they found the contraband?
On her clothing that they confiscated during her initial arrest. It was in her pocket when they arrested her. They put it away. She went to custody. She then pled and was being released from custody. Then they searched the clothing that they had in their lockup and found contraband allegedly in there. And whatever was in the pockets was either already in there but it was not bringing anything into the jail, so to speak.
Was she wearing the clothing when it was the contraband was detected?
No, were you wearing it already or did they give it to you?
I was wearing.
You were
Maybe
already wearing it?
today,
Okay, she was
maybe
already
today.
wearing it, Your Honor, but I mean, she was just getting released from jail.
And what was it that they claimed that she had? Methamphetamine? How much was it approximately, Mr. Yeoman, if you know?
Looking. Well, the defendant did say it was methamphetamine and quote, it was really good dope. In terms of how much was seized, I'm trying to see that. I don't know. I have, before we go too far, I do have some, it looks like 2.68 gross grams. So we don't have the DOJ results, but that would be packaging and the allegedly good dope.
And was it just some plastic wrap or what was it in?
I can't
Can you
tell
tell?
the court that, but I can tell the court is that I have to correct counsel. It looks like to me anyways, the defendant pled out to a felony 594 B1 on May 6th. And it looks like to me, it was credit for time served, that she had 36 days and 18 plus 18, but that's going off memory. And this offense occurred on May 11th, and she was arrested on a trespassing charge and brought into the Public Safety Center. What I have here is she was going into the safety center before transporting her into safety center and escorting her inside. She was asked if there's any unlawful substance or paraphernalia hidden on her person. She told me she did not know what was in her pockets. And then during the search, during intake, that's when they located the white crystal-like substance inside her right coin pocket. And she made admissions knowing the nature of said substance. So those are the facts. So it's not that she was like being released on the prior sentence. They just found it in there.
They ask and they search. That's their job. That's what they do. But you don't understand. It was really good dope.
It's a little more complicated than that. She was on felony probation and she should have been obeying all laws, including misdemeanors. And even before she goes into custody, she shouldn't be using meth.
Mr. Ambrosio, any further comments?
Yes, just one, Your Honor. Even if that is the case, and I'm not disputing those facts at this time, but even if that is the case, she did just plead to a felony, in which case, you know, the people should have brought this case while she was being.
I understand.
That's my son. He, for the first time in his life, didn't say anything to embarrass me. But apparently I have to check Messenger.
Mr. Yeoman, she was released and then booked again, and that's when the dope was found.
This is a totally new case.
Okay.
This is not anything new.
So, counsel, I'm going to set bail at $25,000 in this matter, and she'll be subject to search terms for controlled substances and drug paraphernalia if she does post bail. Did you want to set this for case management conference to see if we can resolve it in 4
Yes, Your
days?
Honor, please.
Okay. And we'll be back in court in 4 days, which will be Monday, May 20th. Or do you want to, how busy is Friday? Oh, Department 4, never mind. Monday, May 20th, Department.
Your Honor, can we also calendar that probation case she just pled to?
If you think there's a chance of resolving it, this matter,
It's not going to be my case. CR-24-005505.
okay, we'll have that on calendar for admitting or denying a violation assigned to Judge Stevens, Department 4 for all purposes.
And Your Honor, is this going back to Department 4?
I'm just handling the arraignments for her. She's in trial, I think.
Thank you.
You're welcome.
I'll come see if I need to know anything, but stop. What? No, just stop. Just stop talking. Talking never got you out of trouble. Just stop talking. Destroying my night. Who I am? This homeless crap is destroying my night. Okay, well. Stop using drugs.
So we're done with her whenever.
I'm ready on Meeks also, Your Honor.
You got it.
I think vagina on the street.
So I have a question. Someone in my Discord last night typed 40, comma 67, comma negative 30. I want to know how Fozzie just knew automatically that was Minecraft coordinates. That was all that was typed. He was on it. He's like, did you just put Minecraft coordinates? I thought that was hilarious. Yes, yes, it is. It was a wrong chat type of deal. Now, I don't know if you remember way back at the beginning, hold on, of this clip,
Is the love made him cry?
Sure,
the
probably.
first thing he says to her,
We need to stop talking.
you need to
okay?
stop talking. Just stop talking. She doesn't want to listen. She just doesn't want to listen. Okay. So I have 2 cases next. Is there a video? Of what? There's probably a video, but I just don't know of what. I'll find it if there's a video, let me tell you. Kelly, I bet you are the ultimate gamer. How's Pog? All right, this next one, there's 2 cases, okay? I got the first case, and then I wanted to show you the very next case, how the lawyer and the judge sort of get back into a groove, but here we go.
¿Quién más necesita intérprete en español? ¿Usted? ¿Cómo te pides? Acá.
Prosecutor's hard to hear in both of these clips. Just warning you now.
Oh, let me get it right. ¿Cómo te piden? Last Balthazar? Yeah. First, Julio. Yep.
I love Skyrim J-Fire.
Calling case number CR 246298, People of the State of California versus Julio Cesar Baltazar. Mr. Baltazar is here in court this afternoon, being assisted by the Spanish language interpreter, Mr. Lopez, certification number 301907 with oath on file. Is the Public Defender's Office available for appointment on this matter?
Yes.
Are you waiving formal reading of the complaint, advisement of rights,
Yes.
enter plea of not guilty?
Yes, Your Honor.
Anything further?
Mr. Baltazar has informed me he has a court date on the 15th.
And the court does note that as well.
I also see that bail in that other matter has been set at over $100,000. Mr. Baltazar is unable to afford that amount by itself.
All right, and Ms. Tao's here for the people. I'll ask.
Yes, I know you can't hear her. It's only for a moment.
I see two convictions he's on felon and then on probation for. One's the 245 and the other one's PC 422.
Yes. Good translation.
Mr. Vela, what is your specific request in this case?
Nominal bail.
All right. Well, the court will set nominal bail and that would be at $1,000. And that's based on my consideration of this defendant's criminal history, the underlying charges, the understanding that this is a charge stemming from an alleged violation or disobeying a court order that was issued in January of 2023. As indicated, I did also see he's on probation. It's concerning to the court that it's the same victim. And at this time, the court has considered the concern of threat or harm to this alleged victim or the public if any other bail was set other than at $1,000 at this time. This case will just be set over one day.
Knucklehead.
No, go to Department 2 in, oh, sorry, at 8:30 on May 15, 2024.
Your Honor, I have a question for the court. Is the court stating that $1,000 is a nominal amount of bail?
In my consideration at this point, that you didn't give an amount, sir. So when you ask me for, let me finish. When you ask me for nominal bail, I do consider that nominal in the grand scheme of things with respect to what is charged and the history. You didn't ask for a specific number, and that's what the court came up with was $1,000. So at this time, I set it over for a day. I can indicate bail review if you would like on the next hearing tomorrow, if you want it noted on the minute order.
No,
But
Your
he-
Honor, and I would like to clarify for the court that when I request nominal bail, it is similar to my previous requests that it be set at $1. My client isn't able.
$1. He wanted $1 bail. So he asked for nominal bail. So guys, from now on, all right, Drongo means knucklehead and nominal means $1.
To afford $100,500 in another case, there is no way that he's going to be able to bail out regardless of what bail is set. By setting bail at $1 in this case, there's a chance that in future bail reviews, bail may be set according to the law. That is why I'm asking for a nominal bail amount of $1. I don't believe $1,000 is nominal. It is not affordable to my clients. It would make total bail $101,000. In addition, I don't believe that there's any authority, and I do believe that there is authority stating that the amount of bail has no rational relationship to public safety.
Understood. My order stands.
So they're annoyed with each other, this judge and this attorney. They're annoyed with each other. So I'm going to put on the next case. So you can hear the annoyance is still a little there, but they get through it. There's nothing crazy that happens in this next case. We're just watching the judge and the lawyer. It's only 4 minutes long.
Last of Reina versus Gabriel.
Right, calling case number CR 246355, people of the state of California versus Gabriel Reyna. Mr. Reyna is here in court this afternoon. And is the public defender's office available for appointment on this matter?
Yes,
And are you waiving formal reading of the complaint, advisement of rights,
yes,
entering a pleas or pleas of not guilty?
yes.
Anything further?
Yes, Your Honor, I'm asking for Mr. Reyna to be released. He has another matter set on Friday. However, the case before the court is simple possession. He has a full-time job working in cabinetry. He stands to lose this job if he's unable to actually attend and perform his duties. Awarding him in this matter would allow him to retain that job, remain a productive member of society. He lives here in County Interlock, and he's willing to abide by, he's willing to waive his Fourth Amendment rights if the court deems that necessary to release him today. He's also informed me that he's no criminal history. He's never failed to appear in court. And that's as much information I have about that. He's also.
How can he have no criminal history if he's pending another case in a different department?
He hasn't been convicted yet, Your Honor.
There's a case he's pending though, right?
There's no conviction.
My question is, you admit that he has a case pending in Department 7, correct?
Informed that he does, Your Honor.
Okay, go on.
He's informed me that he may be able to afford $1,000 bail if the court finds that bail is necessary and that no other means is sufficient to ensure the court's objectives.
All right. Ms. Tao is here for the people. Do you want to be heard on the request for OR? I do see another conviction that was from 2007. Is that correct?
Doesn't matter.
Which is affiliated to the Department of Felony charge. So that's under statement that there's no convictions is just to make up there's paper. So again, people 2007, the PC 273.5 felony, which is prison time, and people will admit that will concede that who has had no new convictions in the past. Catherine Hendricks, prior to that, he has had several felonies. He does have that other, that he's trying to case coming back in Department 9, I think.
I have it in 7, but maybe I'm wrong. I don't know. When's his?
You're
when's his
not
other
wrong,
case coming
Judge.
back in? Department 7.
For this case, people are looking for the search term, the special facility is of the case of during the felonies is just it's just going to appear in that is in charge.
And we talk about search.
I am so glad you said that because with this new software, there's no little click checkbox for closed caption. And I didn't know how that was going to work out. And it looks like it's working out. Yay.
Term, are you asking for him to be searchable by controlled substances paraphernalia? Okay. Sounded like your client was willing to abide by that term if I grant the request for OR. Is that correct, Mr. Bela?
Yes.
All right. I did look at his history, and I didn't see any recent bench warrant history, meaning he does come to his court dates. But at this time, understand this is a misdemeanor case, and I don't see any recent convictions as indicated as well by the people. I am granting the request for OR, but with the search terms that he is searchable by law enforcement for controlled substances and paraphernalia. And this will be set over, which day are we going to? 17th. All right, set over for the 17th in Department 7, 8:30 for your pretrial, sir. So, thank you.
Find the best you can in here, sir. Try to stay in the box.
So there's still a little tension going on there, but they got through it. They got through it. All right. Since we're talking about bail, actually, I'll talk about this after the clip.
¿Vamos afuera? ¿Listo?
Do they not send one?
Sí.
Okay, I'll do another one and, it might just take me a minute to.
It's not in the file. Let me see here. It's not.
I saw one was submitted, but I don't know.
This clip goes perfectly with everything that's being said in chat about bail.
Yeah, it does say submitted, but I don't see it.
I'll just email it to you directly.
Interpreter, your name, please.
Andy Criego, 300-957.
Say that again, 300.
957.
Amy is your first name? All right, we'll get on the record in People versus Jose Anibal Portillo Ponce, case 24-6360. Mr. Ponce is present in custody. Ms. Amy Criego is our court certified interpreter, certification number of 300957. And Ms. Chichportis for the people, Mr. Moth for the defendant. And Mr. Moth, is your client charged by his true name and date of birth?
Your real name and date of birth?
Jose Lopez.
His name is Jose Lopez, Your Honor.
It's what?
Jose Lopez.
Not Jose Anibal Portillo Ponce?
Ese tengo mi licencia.
Perdón?
Tengo mi licencia de ese nombre.
That's the name my driver's license is under.
But that's not your real name.
Eso no es un nombre correcto.
No, es Jose Lopez.
No, it's Jose Lopez.
It's Jose Lopez, Your Honor.
Es Jose Lopez.
So the other name that's on the complaint is what is on his driver's license?
Yes.
Is the date of birth correct?
That your date of birth?
Sí.
Yes.
Okay, Jose Lopez, do you have any middle name, sir?
No,
No.
You don't use your mother's name in there somewhere?
no.
Okay. Remy? Jose Lopez, yes. And Mr. Ponce, do you have the money to hire an attorney at this time?
¿Sí puedo hablar?
Y está preguntando si tiene dinero para contratar un abogado.
Es lo que quisiera ver si puede bajar mi fianza para agarrar un abogado.
That's why I was hoping you would lower my bail so I can get an attorney.
So that's a separate question. My question is, do you have the money to hire an attorney now?
Da dinero para contratar un abogado.
Oh, no.
No.
Public defenders appointed and Mr. Moth, you waive formal reading and arraignment advisement of rights?
Yes.
And the parties would like to be heard on bail, please?
Your Honor, I would ask for the 2-day notice on a bail review, just so that our office can receive the police report and we're in a position to argue from while having the evidence in front of us.
Mr. Smartish?
Your Honor, I would not be opposed to, okay, I should say this. I would like to address bail with the understanding that whatever the court decides, I would not oppose for the next setting to also be on for bail review so that they can argue it in light of having received the discovery. I understand the court hasn't made its decision on whether it's going to hear the bail argument, but that's the people's position that no amount of bail is going to keep the victim safe. So I would like to argue bail today.
Can you tell me the factual allegations that based on the reports that you have, and I am aware Mr. Moth may not have those?
Yes, Your Honor. The allegation in this case is that the defendant and the victim had been in a relationship and have children together for about 15 years. They broke up in May of 2022. The victim thereafter began seeing somebody else. The defendant called a suicide hotline and threatened to kill his wife, his children, and mentioned a firearm. The victim received 15 missed calls from the defendant, 50 missed calls from the defendant before he showed up at the Motel 6. The victim was staying out with the person she was now in a dating relationship with. While she was seated in the passenger side of the car that she was in, the defendant drove the front of his car into the passenger side of her car where she was seated. He then again continued to contact her, and she picked up one of the phone calls, at which point he threatened to kill her. I believe the defendant also called the police, indicating that if he finds his wife, he would kill her. Also, the victim's new significant other was also in the car at the time. The defendant then fled, and there was some type of a police standoff, which lasted, I believe, at least 40 minutes, where he did not comply with law enforcement officer commands, and less lethal force, at which point a canine was deployed in order to get the defendant to surrender. In addition to the facts of this case, I would like the court to know that the defendant has prior domestic violence conviction.
Does that involve the same alleged victim?
I believe one of them, yes, from 2012. If they were in a relationship for 15 years, presumably it would be her. It was a felony domestic violence conviction in 2012. And it was a negotiated resolution, but the original charges also included 136.1 B, subdivision B, which is dissuading while using force or fear, as well as a 261. I will also note for the court that there was also a domestic violence conviction from 2007. And it appears he had multiple cases that were dismissed in exchange of that plea. And those prior domestic violence conviction presumably were on a different victim because of the age of the case. And in one of the cases, there was also an add-on bail enhancement alleged, indicating, which was ultimately stricken, indicating that he was out on his bail or out recognizance in one of the open cases.
Okay, Mr. Sportage, all the events charged in this case are from May 12th. Were there in the month preceding that, was there any contact, police contact, or any other issues that the alleged victim has mentioned to the police?
I don't know when there was, but she did indicate unreported domestic violence. She indicated that she was in fear for her life, and that he would carry out the threat to kill her because he has in the past pulled a gun out on her, and that went unreported, but I'm not sure when that was.
Mr. Moth, anything else you'd like to say at this point?
I would just ask that the court not consider the charges and enhancements in prior cases that were dismissed as part of any plea negotiations.
Yeah. I'm not considering that, but I'm kind of very concerned with the circumstances of this case, and I have a serious public safety concern. And the threats and the allegation of the vehicle being used to ram the vehicle that the alleged victim was in caused me a great bit of concern. So I will set no bail at this point. And you want a bail review then? 2 court days, further bail review?
Yes.
Did you want to set a prelim in advance at this time or not?
No, Your Honor, we're going to probably waive time generally afterwards, but we would like to resolve the bail first.
Silvera's here Friday, right? We said.
Every day, every single day.
Okay, thank you. I've forgotten. Okay, so Department 4. Okay, then we'll set this for a bail review on the 16th of May next, it'll be on Thursday if that works for everybody.
That's fine.
That'll be at 8:30, Department 4. At this point, she has 7 cases on calendar, so that should be able to deal with that then, okay? Thank you.
Your Honor, the people are also requesting a criminal protective order, and I think it's somewhere in outer space.
Okay, so you're requesting complete stay away order?
Yes, Your Honor, of the 2 victims.
So the other person in the car and the alleged victim, Mr. Moth, what's your position on that?
Okay, if you stay away from this person. Same.
Yes.
He has no objection to it.
He has no objection?
No objection.
Is that it there? Okay. Right, so, so I'm gonna order that you not have any contact with and stay 100 yards away from thank you. Ezekiel. I'm not sure if that's spelled right, but the way it's spelled is Ezequil, Mendoza, Mendoza. We can correct that if that's wrong. And then Carla, yes, Carla with a K, De Los Santos. You need to stay from 100 yards away from both of them. And that's good until modified by the court. And is there any indication, but you said there was some indication in the reports that he threatened the victim with a gun, is that right?
Yes, Judge.
Mr. Moth, is there any reason your client cannot be sworn with respect to firearms?
No.
Sir, if you could please raise your hand and be sworn.
Do you follow the testimony you shall give in the matter now before the court that we
Same.
Yes.
And Mr. Moth, my one question will be, do you own or have access to firearms? Any objection to that?
Nunca.
He definitely does. Definitely.
No objection to that question?
No.
Okay. Mr. Lopez, do you own or have access to any firearms?
Sí. Sí, senor.
Nunca he tenido armas.
I've never had
Okay.
firearms.
All right, sir. Ed, you cannot possess any firearms during the pendency of this protective order. So that is the order of the court. You have to stay away from the two persons I named, and also you cannot possess firearms. And you'll be back in court on Thursday for a bail review.
Your Honor, if I may, I do believe it was misspelled. If I can just write it. And
Yes, it should be Ezequiel.
yes. Thank you.
We will correct the name of the passenger in the car. Ezequiel.
Thank you.
Is that right? When I see it, E-Z-E-Q-U. Yeah.
How do you
When I
spell
had
it?
to write it down and make sure it made sense. Okay, thank you.
You know,
Do you have anybody else running?
thank you.
So the reason why I played that one is because we keep seeing these people get out on bail, get out on bail, get out on bail, get out on bail. No bail. No bail for him. None. So she's safe for a bit. And so is Ezekiel. All right. This one, I cut the whole first out because it was boring. All we care about now is the end, where the judge and the lawyers are talking. And the one lawyer almost leaves because he gets so frustrated. He is just misunderstood. He is. Hey, no soup for you. We love soup. Kathy with a Y. I don't know why. I feel I have a common name. I feel my name is not that hard, but the way I spell my name has been just an ongoing thing. Yep, our Sarah in the blue dress can fix that. Can fix him. All right, here we go. Fighting attorneys.
And in this case, I don't even really think it's a close call, to be honest with you. This is not a custodial interrogation. And the court,
I can't boost her sound anymore because if I try to boost her sound, it garbles. If this sound is just bad, let me know and I'll just stop it.
is going to allow, assuming a foundation can be laid, it's not going to be inadmissible because of a Miranda violation. So I need to take up a plea and I need to talk about scheduling tomorrow. So I'm gonna have the jury present at 9. So I'd like you all here at 9, and we can start with voir dire. And before I do that, I have one final question to ask. Was there any idea or inclination to try to settle this case at all?
Yes, we've offered a misdemeanor and they want a felony, and I don't think that, one, obviously, I don't think even any criminal conduct is.
But I just want to know efforts to settle.
But this is cases with misdemeanor.
And Mr. Langston, what was the people's position?
The people have tried to settle this. Our last offer at the last trial was a felony credit time served, and the particular reason for that offer is because he was on felony probation at the time that this incident happened.
Okay, well.
That's
and I
better.
suppose there's no room for negotiation between, for either side.
Yeah, I don't know what the room is between
Well, it's,
felony time
if
served.
he loses and he gets convicted, he doesn't get credit for time served, probably. And he gets remanded and taken into custody, probably, although that, that has to be determined.
Yeah.
And, those are the kinds of things that I would think somebody would consider. I don't think that, I'm not sure I don't really know all the evidence, but it seems like it might be a bit confusing for the jury to understand.
If 12 people say that are gonna vote for guilt on this, I'll retire. So.
Connor, it sounds like that what the people are saying is that at the time he was on felony probation. That was back in 2008.
I know.
That's not true either.
Well, okay, but what Mr. Bashir is saying, look at how much time has transpired between the filing of this case, which was October of 2019, and to today's date, 5 years. Have there been any other criminal acts or charges or?
No.
There are none. This case has been significantly delayed when it was in the previous department. We made multiple.
5
efforts to
years.
resolve.
That's not at the fault of our client. That is the
No, I know. I think Mr. Langston's just trying.
For 9 months and we're at trial already.
I understand that. All I wanted to know is,
what I would say, just speaking as a manager from our office, is that it's of no fault to
Right.
to this client right here, that this case has continued to get reassigned. It sounds as though he has not picked up any other cases, and that is a long time ago.
There's
That
no
is a
sound on this
significant
clip,
amount of time.
Raven.
I can.
It
see
should
why
be
Mr.
muted.
Harrington would be asking for a misdemeanor, and if the only reason that this is offer as a felony is because he was on probation in 2018. I mean,
I don't know what his criminal history is. Right now, I looked at the file. I don't have any information about his criminal history.
it just seems as though it's not an unrealistic request to ask for a misdemeanor. I mean, there could be some jail time associated with it, or he could do the ankle monitor or do the work days. I just don't see the difference between if he's been this successful in not picking up crimes, it's just a 2-year felony probation.
Is it a wobbler?
No.
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 Well, the reason I ask that is because if this case had been resolved years ago, he could have already come back to the court and asked for a
It's not a
1203.4
wobbler, but
motion.
he's demonstrated that he's not picking up any new cases, staying out of trouble. I can see if this were a recent case, maybe the people would want felony, but I mean, I just don't, that seems, for purposes of trying to resolve it, I don't think a misdemeanor seems unfair.
Your Honor, there's more to the story, and I would.
I don't know. The problem is that if Mr. Harrington has only had the case for 9 months, then what Mr. Langston's saying, that it's been continued so many times, we wouldn't have the appropriate people here to address why.
I don't think it even matters at this point in time why it was continued.
I'm just trying to understand, the different, Mr. Langston said it was a
I
length of
just
time.
mentioned that to say that we've been actively trying to resolve it.
Well,
during that
I
period.
understand that, but we can't speak to what the other attorneys who had the case.
Okay,
previously-
I don't think, I don't, the length of time only matters insofar, in my opinion, as it demonstrates a period of time that Mr. Wright has not been in trouble.
Correct.
Whether, whose fault that is, I don't care.
Well, what I'm trying to address is that we don't know who the attorneys were previously and why they wouldn't, what the issues were with resolving it or not. All we know is that Mr. Harrington has had it and he's tried to ask for a misdemeanor, and that doesn't seem unreasonable.
If the people would have charged this under the correct subsection instead of going for blood over nothing, then this case would have been resolved a long time
I
ago.
don't think it helps to say going to blood.
It's the truth.
Well, no, but
It's the truth.
how is that gonna help resolve anything? It's not.
But we can't resolve it and the court can't do anything because of the way it's charged. I mean, Judge Reeves spent like 10, 15 minutes with them trying to get him to give a misdemeanor.
Okay,
But
I'm just saying, I don't think you're helping right now. I think you're hurting right now.
well, that shows how powerless we are in this situation, even though we're trying.
Okay. Okay, Madam Clerk needs to be gone, but I just, Mr. Layson, are you saying there's absolutely no way and under any circumstance you would not accept a misdemeanor resolution?
We were ready to revoke our offer and we pulled up the officer.
Was it ever a misdemeanor offer?
My
Sorry,
knowledge,
Judge, we're
but
gonna get going so we can, this is pointless. We've been doing this for
I
months.
haven't heard from him.
We're going on for months. I mean, let's just do the trial. Let's
See,
do the trial. This is
Yeah.
really important and let's do it.
Good, it's okay, just take a beat.
So was there ever a misdemeanor offer made?
to my knowledge, there has not been a misdemeanor.
So that, so would, I mean, I'm just asking you, would there be any circumstance that you would consider offering a misdemeanor? And I say this because I think it's significant that Mr. Wright has not been in trouble in the almost 5 years since this case was filed.
Sorry.
Just let Ms. Brashears do the talking. I think that's the best thing.
I have been in contact with the victim and the landlord on this case. They're still afraid of Mr. Wright to today. They are afraid of what had happened around the time of the incident.
Okay, but,
That's not relevant.
can I just ask one other thing? Has there been any reason to be afraid other than these charges? And I would understand it. I'm sure this is scary stuff. But what I'm saying is, has there been any contact between the two of them or attempted contacts?
So just to give an example of what I'm explaining, this is a Bates 9 discovered.
But she's not talking about
Just let him finish, Ms.
This
Brashears.
was July 2nd, 2018, and Mr. Wu had to call and report that Mr. Wright had been pretending to be an officer, demanding that he open up the property. He explained on another occasion, and I know this will probably not come out in trial, that a transient came and approached him and said that Mr. Wright was trying to hire people to damage the reporting party's property, and that Mr. Wright was going to provide $1,000 per broken window. This is just an example of
Okay,
why.
but since then, has there been, I mean, that was back then, has there been anything that would make it seem understandable that there's been a present fear now? I mean, if there's been no contact in 5 years.
When I spoke to each individual, they are still afraid of the same things happening again. They still have that from what happened before, and I think that the fact that the nail went through Mr. Speckman's toe is so incredible. I understand why they want to get a misdemeanor, but the conduct, it's like almost close as a balancing that someone had their foot, a nail go through
Okay,
it.
all I wanted to know, was there any circumstance that you would consider a misdemeanor offer?
No, Your Honor.
Let's just do the trial.
Well, I can't force it.
I understand.
Let's just do the
I
trial.
understand.
I know we can hear from one attorney at a time.
I understand, but what Mr. Langston is referring to are things that their office should have chosen to file charges against. They charge this as whatever section this booby code, this booby trap is, right? And what he's talking about are things from the same period of time in 2018. And if they wanted to file charges, if they think they had evidence to file charges about an injury on a toe or them being afraid of something, they could have filed those charges. They've had every chance, just as much as we've had to try to resolve this case, to file the correct charges in this case. If that stuff is not relevant and not going to come into a trial, then I'm not sure why he's even talking about it right now. If he has not contacted these people in 5 years, he's a business owner. He's trying to live his life. He's trying to move forward with his life. If he was going to contact them, that would have happened. I understand that they have issues and they have things that they need to resolve or whatever that is, but their office could have taken all of this time that this has been going on to file those particular charges if they have the evidence. If they don't, I'm not trying to be rude or callous, but it's that there are things about cases that just don't come into play.
And I would just say this, why in the world was this guy doing a lockout without the sheriff in the first place?
Okay, why are we hearing from two attorneys at the same time? That's not, I mean, I want to hear from one on each side.
I thought Ms. Brashears was finished.
She's representing Mr. Wright right now for this discussion. Okay, well, I don't think it's gonna resolve. Doesn't sound like it is to me. I really wish it would. But I don't have control over that. I only have control over certain things, and whether the DA's office is gonna offer a misdemeanor is not within my control. I think everybody understands that. So I need to do something.
He's also saying now that he would like to find another attorney.
Not doing that. We're going to trial tomorrow.
Thank you, thank you, thank you,
You know,
thank you,
I-
thank you, thank you.
It's on the record. I understand you want to make that request. It's too late to do that now. That request should have been, that should have happened long before the eve of the trial. If you had a private attorney that came in tomorrow and said to me, I'm ready to take this case, I've been retained and I'm ready to go tomorrow, that would be different. But I'm not continuing the case for the speculative purpose of hiring a private attorney that has not yet been retained when we're supposed to start the trial today at 1:30 and actually have already with our motions in limine.
Well, I've been through 9 different attorneys, so.
Well, I mean, I'm sorry that happened, and that is really beyond my control. And
9. He's been through 9 attorneys. 9.
it's really just beyond my control. And really, the decision should have been made earlier than today.
I was thinking about it, just I couldn't get a hold of this other one.
Well, and that's,
And I thought we were gonna already settle this thing.
I'm not going to continue a case from 2019.
18.
Well, it was filed in 2019.
The alleged incident is from,
Oh, okay.
this is a very old case, Your Honor, and the only other thing I would say to Mr. Langston in just trying to get this resolved is that things that he's saying are of interest to the victims are also things that may not even be able to be considered by a judge at the time of sentencing. And so if that's something that he thinks he was going to argue at a sentencing, he may not be able to do that. So I'm not sure why he cannot tell us any other reason why this shouldn't be a misdemeanor than things that really aren't relevant.
Okay, and I don't know, because I haven't heard the evidence yet, but now that I see it's a 2018 case.
I believe this would easily be resolved if a misdemeanor offer could be relayed. I don't think jail time is the issue. I think it's just that he is a business owner. He has not contacted these people. He doesn't plan to contact these people. He is trying to put this behind him. He is trying to do the right thing as a citizen. He is a business owner who's trying to move forward with his life. And if it could get resolved as a misdemeanor, everybody could do that. He's not going to contact these people. He has no intention of contacting these people.
All right, well, I appreciate the information. I'm not empowered to do much.
I understand.
With that. I have
I'm a
to do
professional.
something with the felony plea. My clerk has to be gone. It's 4:15. I'm supposed to be in a meeting. I'm inclined to put it over until tomorrow morning. So I don't really have a choice but to do that.
Okay. So what happens tomorrow?
The first, that would be helpful because I'm sure nobody will be ready right at 8:25. And if you're here at 8:25, I can call that case. And is there a time where he's supposed to call Miss Evans? That's my last question. I'm gonna call and put it over.
Carol Spurgeon, sorry if I said that wrong. Thank you so much for becoming a member in Patreon. I appreciate it. I very, very much appreciate it. Okay, now it's time, guys. It's time to head to the pro se who read a law book. I don't know which book. It might have been more than one book, but I doubt they read it. Anyway, this person's in trouble. This person does not make the judge happy at all. And it is Judge Frost in Wisconsin. But don't worry, it's not child support.
Who are you?
This is Lance Raceland.
Okay. And Ms. Salvanos, is it just you today or is your husband on the phone with you?
Yes, I'm here, Stephen Albanos.
Okay, great. Mr. Wrestler, can you hear me okay?
Just fine.
And attorneys Dodge and Rice, can you see and hear me okay?
Yes, Judge.
Great, thank you. Attorney Dodge, I couldn't tell if you said yes.
Loud and clear, I said thank you.
Perfect. I'll call case number 2023 CV 1365. Shauna and Stephen Alvanos versus Wrestler Inc. et al. For the appearances today, I have the plaintiffs on the phone together calling into the hearing. And then I'll let counsel state their appearances. Attorney Dodge, could you get us started?
Sure. Christopher Dodge appears for Wrestler Inc. and Lance as well, who was with us by phone.
Thank you. Attorney Rice?
Attorney Richard Rice for defendants Phil and Heather Clybourne, Your Honor.
Great, thank you. And I have both attorneys by Zoom video today. I've confirmed each of you can see and hear me. I can see and hear both of you as well. And then our participants on the phone, I confirmed each of them could hear me and I could hear them as well. And we're live streaming since we're doing your hearing by Zoom today. So we're here because a motion for relief from judgment was filed. I got a motion, so I put a hearing on, and then I did get a response brief opposing it. That was filed May 7th. And then on May 8th, the Clybours joined in that opposition brief that was filed by the other defendants. Mr. and Miss Alvanos, did you get copies of the brief that was filed on the 7th?
I have via the e-filing, yes.
Oh, right. I forgot. You're not the typical pro se party, so you have the electronic filing. Good. So
Yeah.
why don't we use our time today for you to argue if you want to contest anything that was in that opposition brief, and if you feel like there's anything you really need to point my attention to in your own motion, why don't you do that?
Okay, sir, thank you very much. I really would like to ask you if you could please subpoena Heartland Credit Union for the appraisal of the property of 1766. That would help distinguish a lot of different questions about what the appraised value is, who the financial institution is, and we know how much was paid. That was $200,000. But I think the appraisal would really help answer a lot of questions in this for us, for all of these cases, literally. And let me just, I'm pulling up the motion for them to dismiss here. I know that I haven't filed an affidavit. I did do an open records request from WIDA on March 25th. I've never done an open records request. I had to buy a computer to do all of this legal stuff. So in the open records request, WIDA did inform me that we had been eligible for a loan for our house that we lived in for 13 years. And it was approved on April 17th. But Heartland Credit Union stopped communicating with WIDA on April 21st, meaning that WIDA had the funding, but Heartland Credit Union told us, no, you don't have funding, and they let Clybourne buy the house out from underneath us. So Heartland Credit Union withheld our funding to deliberately enrich another person. So as I look at the motion to dismiss, again, Attorney Dodge is trying to remove Lance Rossler Inc., which he has tried to do multiple times. I honestly, the only thing that will really help at this moment is, since we are waiting for the appeals cases answers, is to have the appraisal, to see everyone who is party to this, to be able to visually see the appraisal, whether it's paper or electronic. And it should be with all of the cases, all the way up to the FBI. That's something that Your Honor would be able to do.
Just say no and move on.
Or
No.
perhaps circumstances in a civil case, the law does provide when unrepresented parties, meaning people who aren't lawyers, need a subpoena, they do present a proposed subpoena to the court for signature, because lawyers by law are allowed to do that. Non-lawyers are not, so then you need the court to step in. But we're not in the case, we're after the case is closed. So I don't see how there's any way for me to help you order people to produce documents because we don't have an open case.
Well, it is still open. It looks as it says it's open because it is in appeals, and that means that the Liz Pendens is still in application because the case is in appeals. So I guess I don't understand why the appraisal couldn't be shown to all of us. It seems like it would answer questions for you, for me, for the FBI, for the captain of the Fitchburg Police, for the DFI, for the NCUA, multiple questions, the IRS. The appraisal is the key and the answer to all of these cases.
Well, you just listed a bunch of
This was, they were
federal-
lit on the property on May
Ma-
18th.
Ma'am,
Yes,
you
sir.
listed a bunch of federal agencies. They don't need my help, and if they did, they would ask for it in a different context. They have ways to get documents if they really
Okay.
want to investigate things. They're not parties to this case, so they couldn't ask me in this case anyway.
Right, no. I'm asking you because we've gone through a lot of pain and suffering because our bank, our credit union of 10 years withheld our funding. I'm on, do you know what it's like to be homeless? We're still homeless. That's why we couldn't zoom in. This has ruined our lives. So
Yeah,
I
so-
think that we deserve to be able to see the appraisal.
Let me,
For circumstances, as
ma'am,
the
let me
honorable judge
respond a little bit on
decided.
that, okay? Miss Alvanos,
Yes, sir.
so you're asking me and you're talking about, you believe there's an appraisal that Heartland Credit Union has that would show that Heartland Credit Union didn't tell you the truth and therefore prevented you
Yep.
from getting financing to purchase this property. Even if I accept that all that is true, how does that help you as against Wrestler Inc. or the Kleinbauers, which are the only three people involved in this case? Heartland Credit Union is not a defendant in this case.
No. Well, Your Honor, as I am not an attorney, and after I figured out that these people conspired to steal our house out from underneath us, and I finished crying, I decided to read the law. And when I figured out over Memorial Weekend, I filed the quiet claim for title, adverse possession, and the Liz Pendens, honestly hoping that I was able to stop something because it had my day in court so that I could be heard, because this was, we put 13 years into that house. That's a lot of time and a lot of money and a lot of repairs. And our whole entire income has been ripped away. My husband's drywall business is in that area. Our catering kitchen was in that area. His lawn mowing and landscaping, snow plowing business was in that area. So we have had our whole entire income ripped from us. So when I filed those original cases, honestly, I didn't know what I was doing. And I'm still learning because I'm not an attorney and I can't find one. It's either the wrong attorney, they're too much money, $50,000 retainer is a lot. So now after that, I got the appeals and they're waiting on the judges to decide. I filed a federal and a civil breach of contract against Rossler and Rossler Inc. And then I filed a federal and civil prohibited business practices.
Judge, could you possibly mute? We're getting some background noise. It's a little distracting.
Kitty.
Mr. Lance Russell, thank you. Sorry to interrupt.
No problem. Mr.
Judge, can we just all pet the kitty and then we can worry about this craziness afterwards? That guy needs to open the window. The kitty is looking directly at him saying, let me in and feed me.
Wrestler, I think we are getting a little noise from your end, so I'm going to click the mute button. And then if you need to talk, I can't remember what you have to push. So maybe if you could actually just mute your phone.
Sure thing.
All right, may I finish?
Yes, please do.
All right, sir. So after we had our day in court with you on the 30th of November, or the 29th to 30th, we were peacefully evicted from our house after staving off eviction for 7 weeks and 6 days until we were refused to pay the person who stole our house. and to be locked into a nonverbal 12-month lease, or to even admit that they were our landlord. That's impossible because we were purchasers of value. So after January 29th, I finished reading. I filed the federal lawsuit against Heartland Credit Union, federal and civil, Heartland Credit Union and Phil Kleiber for an artifice to defraud, honest services, conspiracy to commit theft, criminal slander of title, disability discrimination, fair housing, fair lending violations, and equal access to credit violations. In those two federal cases, I have just been assigned a new judge because she has just been appointed, and they are awaiting investigation to see if I have a valid claim. And then the two civil cases, briefs have all been added, and those are also waiting on judges' decisions. And here we are today. I think I've covered what I needed to cover. Yeah, so if we have that appraisal, you would have answers. Judge Remington could have answers. Judge Elke could have answers. Judge Peacock would have answers. And then Judge Bohr in the federal court would have answers. And we could all be done fighting about this. This has been a very traumatic thing for my family. My son ran away.
And the tears.
I'm sorry, I don't mean to be emotional. So thank you for letting me talk.
Yes, of course, I understand. Okay, I'm gonna let the attorneys respond if they would like. Attorney Dodge, do you want to start? Do you have anything you want to add to your brief?
Yeah, just as it relates to what's been discussed so far today, I think the court is aware, based on your questions, that the appraisal has nothing to do with this case. Heartland is not a party to this case. My client had nothing to do with the financing other than as a offerer on a potential purchase. And in the end, the offer expired. My client moved on and sold it to a third party. So
your contract.
Ms. Albanos, if you're going to talk with your husband, could you mute yourself?
Yes, sir.
So yeah, my client was unaware of any of this WIDA stuff. We were just basically waiting around for them to fulfill the terms of the offer. They didn't. So I think the issues that she's raising today may apply to one of the other many cases, but not this one. And as Ms. Albanos brought up, and as you can imagine, the frustration on our part, we are now, between Attorney Rice's office and mine, we're now dealing with, it sounds like 6 cases and 2 appeals, all out of basically the same transaction. This case was filed, summary judgment was granted, there's an appeal pending, there's been a motion to consolidate that's been denied, a motion to stay the writ, which was initially denied, motion to lift the stay, which was granted for a period of time and then denied later, motion for reconsideration, a motion for relief denied by the Court of Appeals, and then now this motion. I don't know the detail of Attorney Rice's case with the Kleebauers, but there's the second case, and that's in front of Judge Remington, where the Kleebauers were evicted. I'm sorry, where Albanos was evicted. Trial was on October 6th, 2023. Eviction was granted, and since then we've had a motion to reopen, a motion for relief. They filed a motion for appeal. Remington denied a motion to reopen. There was a motion for a new trial, which was denied by the Court of Appeals. In that case, and maybe Attorney Rice knows more about it than I do, but on October 20th, 2023, Judge Remington cautioned Mr. and Mrs. Albanos relating to mass filing, citing 802.05, warning them of sanctions for groundless motions. The Court of Appeals granted a temporary motion to stay the writ that was later lifted. There has been since a motion for reconsideration, which was denied, a motion to consolidate, which was denied, and a motion for relief, which I believe has been denied. There's a third case in front of Judge Peacock, 24 CV 256, which to me, and well, someone's going to complaint filed. We filed a motion to dismiss saying basically it's the same case that was in front of you, Judge Frost. There's a fourth case, 24 CV 257 in front of Judge Elke. I'm not a party to that, but from reading CCAP, the Kleebauers and Heartland Credit Union are. Summons and complaint filed. Motion to dismiss is pending. We weren't sure, but we had heard rumblings of 1 or 2 federal court actions. So I know more about it right now than I did before we started this hearing. So we're, beyond the context of this case, and I don't assume the court can go beyond the context of this case, but we feel that we're being subject to an abusive process. This is an incredible expenditure for my client to fight each of these cases and all of the motions in each of these cases. So we are looking for your help, Judge, and any guidance you can give. I also need to point out one thing that it's particularly irking, and that is there are statements being made in the pleadings and today that would be frivolous outside the context of litigation. Stole our house, we would consider a frivolous statement or a defamatory statement. I've been accused of evading service, which is absolutely not true. My client has been accused of abandoning his godchildren, his business failing, run out of town by bikers, any of that he's currently in hiding. So we're, not only are we dealing with cases, but we're dealing with accusations and allegations and cases that are very inflammatory. So we are asking the court for any assistance we can have. As it relates to the motion, I already addressed the Heartland issue, and I have nothing to add to my brief.
Hi, Melissa.
Your request was a little bit vague when you're talking about any assistance. Is there anything in particular you're asking for?
Well, perhaps it will require another motion, and I know I can't and won't discuss about what that motion needs to be, but I guess that what I want to do is look to the court.
Melissa, we're guessing. We're just guessing here that Victoria is going to make sure Fleischer plays hooky from that conference today. You got to help Victoria make sure Fleischer plays hooky.
To the fact that we now have 6 lawsuits and 2 appeals pending on this, in some sense, the same case.
Sure. Okay. Attorney Rice, did you want to add any argument?
Just very briefly, Judge, because I joined Attorney Dodge's arguments, both written and spoken. As you have stated, Judge, Heartland Credit Union is not a party to the action before you. And that seems to be where Alvanos are going with what they're stating to you about wanting an appraisal from Heartland Credit Union. My general awareness, I'm not aware that there is any what I would call formal appraisal that I know of for this property. Whether it's relevant or not is another question.
Not relevant.
The reference Attorney Dodge made, so you have it, is to case number 2023 SC 5265 before Judge Remington. That's the eviction action. And the docket 52 is Judge Remington's memorandum on decision and orders denying defendant's motions, various motions to stay the proceedings and the writ of restitution that caused the eviction on November 30th, 2023. And that's at the end of that motion where he warns the Alvanos about potential violations of WSStat section 80205. It's just, this is, I understand what the Alvanos are saying, but the harsh reality, and you know it from the case before you and all of those filings you talked about very well on November 28th, 2023 in the hearing before you, that the reality of this matter is the Alvanos were tenants and therefore renters of the property. The property was sold by Ressler to Kleibors, and the rest is history. I don't know what else there is to say other than one minor note in the motion on Exhibit A. If you look at the bottom of Exhibit A, it very, very simply says, the WIDA document, this loan is pre-qualified. Please note that this certificate is a pre-qualification only and is subject to submission and final underwriting. Now, from my knowledge of loans and things, though I'm not a loan officer, is that pre-qualification is not meaning someone is qualified for a loan. Not that it's relevant at this point because that's between HCO and Alvanos, but just to alert you to that information. Thank you, Judge. That's all.
Thank you. Mr.
Your Honor.
or Ms. Alvanos, any final response before I decide?
Oh, yeah.
Yes. Yesterday morning, I received from the Department of Revenue of Wisconsin that they did take out a conventional loan. We were never tenants of the Clybors. That's why we chose not to pay $500 in rent because we are not tenants. They're thieves. We have proof that Lance was asking for permission to let the appraiser come over on May 18th, 2023. And I was on the phone, incidentally, with Jeff Roush, the Vice President of Lending, when that appraiser was at our house. I know that this is a lot going on. I'm not an attorney, but to file this many cases means that there's something going on. If I was able to stave eviction for 7 weeks and 8 days, that means someone believed I had a valid point. I was a purchaser of value, and even Judge Remington said, Mrs. Alvanos, if you can prove that you are the victim that you say you are going to dig yourself out of this hole and then some. Well, I plan on digging myself out of this hole and then some. Being homeless is extremely painful. And I would like to see the appraisal so that we can move on with all of the other cases. They could probably just be done if we had the appraisal and we're able to see who signed it. Was it through Heartland Credit Union? Whoever Lance had onto that property is the appraisal. And I want it from them, and it's most likely from Heartland Credit Union. But I don't know for sure, and I'd like to find out. You can't just get $200,000 cash and pay without the IRS knowing. So the Department of Revenue doesn't know. The Wisconsin DFI has no idea because, surprisingly, they do not regulate Heartland Credit Union, nor does the NCUA, nor does the Secretary of State of Wisconsin. Heartland Credit Union is an unregulated financial institution. That's what I've discovered in my findings. Judge, I have nothing else to say. If you could rule on the original case that I filed in May 31st of the Liz Hendon quiet claim to title and adverse possession, being that this is actually a theft, and change the deed back into the Alvanos name, that would be wonderful. Or a subpoena for the title or for the appraisal. And I'm working with Captain Hartwig of the Fitchburg Police and FBI agent Miguel Miranda. That's all I have to say.
Okay, guys, listen. Judge Frost is about to speak and about to make everything completely apparent.
All right. Thank you for your argument there. I'll give my ruling now. So I issued my original final order on this case on November 28th, 2023. It was put into writing and entered into the record with my signature on December 8th, 2023. Document number 245. At that point, I had ruled on a few different motions, denying a motion for appointment of counsel, denying a motion for relief from judgment, granting summary judgment in favor of each of the defendants, and then I vacated and released the list pendants in that order. So all of that happened, and I explained in quite a lot of detail on the record. We didn't put it all in writing, but it's all in the transcript. Exactly why I was doing that, based on the submissions from the plaintiffs, which I read through over a significant amount of time, which you seem to have suggested that I just didn't comprehend what was going on or didn't get my arms around the case, Mr. and Ms. Alvanos. I did. I spent actually quite a lot of time on your case. And for all the reasons I explained on the record, I simply found that by your own submissions, you're wrong. And that you have not been defrauded by anyone, and that the person who was kind enough to try to work with you under a land contract type situation and then switched it to a landlord tenant, but still giving you an opportunity to buy, gave you every reasonable chance, and you just didn't get the funding lined up in time. And it was a stretch because you waited so long to even try to get funding in place. And Heartland told you that, and others told you that. Heartland's not part of this case. And in your motion and your argument today, you haven't pointed me to anything new that changes any of the information that I relied on that you submitted, or any of the findings that I made that were relevant to the claims raised in this case. The claims raised in this case that you filed were really, who is the rightful owner to this property? And based on everything that was submitted, most of it by you, it was clear that Ressler was the owner, and then they sold it to the Clybors after the time period that they gave you for you to try to purchase it came and went, and you didn't get the money to purchase it. So your submissions, a lot of them, frankly, match what you'd shown me previously, which was that you were trying to work with WIDA, that based on the numbers for WIDA, you should have qualified, and that you were trying to then work with Heartland to actually fund your mortgage and to give you a mortgage so you could purchase it. None of this changes anything that you submitted to me before. It just adds more, essentially more documents that tend to show the same storyline. So it's not any kind of a basis under 80607 for me to grant relief from judgment, though these specific documents theoretically might be ones you didn't see before. Not newly discovered evidence that entitles you to a new trial, because it wouldn't change anything the way that you showed it. And you haven't pointed to any other aspect under 80607 sub 1 that would form any basis for me to reopen the case or to vacate the judgment that I rendered. If anything, these documents just tend to confirm what I had already found. So there's no basis from your motion for me to reopen the case. Without reopening the case, there's absolutely no way and no authority for me to sign on your behalf any sort of subpoena to any party to appear for a hearing or for third-party discovery purposes. The right to third-party discovery only exists while a case is pending and has not already reached a final order. This case has, and I'm not granting relief from it. I do feel sympathetic to you in that I don't like anyone being homeless, and I know that it's for all the emotional reasons you.
It's because all he does is cases that are emotional, divorce, lots of divorce, land contracts. So yeah, he's being as kind as he can be because it's the best way to get through it.
Pointed out, leaving this home was a very difficult thing for you to have to do, especially when other people were telling you you had to do it. And though I feel sympathetic to that circumstance for you, it doesn't change the law. It doesn't change how the law is applied to the facts in this case. So for all those reasons, I'm denying your motion for relief from judgment. I didn't realize till we got here today, and you pointed it out first, Ms. Alvanos, and then Attorney Dodge pointed it out as well. I had no idea that there's additional cases pending between you and these parties. Separately, it appears, in different cases. I have been a judge who has had to issue orders.
Hey, Raven. See Judge Frost? Do you see Judge Frost? Do you see the board behind him? That might help you figure out what state we're in.
There's prohibiting a party from filing additional lawsuits without getting approval of a court before they can do so. I've had to do that in the past. When I've been able to do that, it's been because one or two, or unfortunately sometimes 3 or 4 other judges had had those cases, warned parties, and a party continued to ignore warnings and violated those instructions by filing.
Yes, I usually stream in something like this. It's big. It has a whole bunch of fur on the inside, not fur, but you know what I mean. Soft, soft, soft. It's huge. It has pockets. It has pockets. It really does. So I'm all comfy in my little chair. Yes. And I'm a lumberjack.
Frivolous cases over and over. I do see that, I appreciate Attorney Rice pointing it out. Judge Remington did warn you, Mr. and Ms. Alvanos, that under WISSTAT section 802.05, you can be sanctioned for these kind of filings. And that was warning number one. I'll agree. In this case, I ruled against you, and you have filed a number of motions at different times in this case. I don't know that any of them reached the point of frivolous in this action, although this one comes closest to having no basis in fact. But you had made a request for appointment of a lawyer that was, I can't say it was completely without any basis to even ask, but that I ruled against you on everything doesn't automatically make it frivolous. I am concerned that I see you filing lawsuits against the same parties, apparently over the same interaction, especially when I consider the Clybors, the only connection they have to you is they bought the property that you would have liked to be the owner of and you would have liked to purchase. I've resolved that they lawfully bought it, as you asked me to in this case, and that they're clearly the lawful owners currently. It's beyond me. I haven't read those other cases, but it's beyond me what could be in there that's different from this case. I will give you a warning again, and we will put it in writing, that continually suing over the same claims and trying to raise new claims out of the same set of facts is inappropriate. And that if another judge after me determines that the one in front of them is one of those that Judge Remington and Judge I are warning you can't file, you can't just keep suing the same people over the same interaction. You get to sue somebody once for a transaction, we call it. That issue or claim preclusion relates to a transaction, meaning sometimes it's a real contractual transaction, sometimes it's, for example, a car accident, you could call a transaction in a personal injury context. It's when an activity, when an event happens between parties that leads to claims, you need to bring all the claims that relate to that interaction in one lawsuit. And this was your lawsuit to resolve ownership of the property. The eviction was a lawsuit filed against you to evict you on the basis that you didn't have a right to be there. So those are different because an eviction has to be brought in its own context. And this case is the broader question of who owns the property. So I'm giving you a warning that now that I've resolved who owns the property, you can't keep filing suits against these parties hoping to find some new way to win and get back your property. That doesn't mean I don't know what evidence theoretically you might uncover and if it would show that there was some other interaction. But I'm putting my warning in writing. It'll be in an order that I'm going to type up that tells you continually suing these defendants over the same thing and just trying to come up with new names to call it. We're each giving you a warning, and the next judge, I'm encouraging, if they find that it's frivolous and that it's you filing the same lawsuit, should take an action to prohibit you from continuing to file any more lawsuits unless a judge approves it before you even get to file it. And that they should consider imposing any other sanctions that they deem appropriate. Mr. and Ms. Alvanos, do you understand the warning I'm giving you today?
We understand.
Attorney Dodge, is there anything else you'd like me to put on the record today?
Nothing further for me. Thank you.
Attorney Rice, how about for you?
Nothing further, Judge. Thank you.
And I do notice, I think that what you must be referring to, Ms. Alvanos, you said the case is still open. I assume that's on the CCAP website that it says it's open. I just noticed on my record, it says that as well. We'll be marking it as closed. I entered my final judgment some months ago, so it is a closed case. I said so in my order. The CCAP site is just a useful tool. It's not the actual case record. I was very clear that I closed the case and I made my final order when I issued that order back in December and in November when I orally entered that order. But we'll correct the CCAP website to also reflect that. Okay. And then if you happen to need anything else through another motion, Attorneys Dodge or Rice, feel free to file that if this case is the right one for it.
We made it. We made it to the end. And there was zero Judge Fleischer involved at all. Imagine that. Imagine that. However, when I first started this stream, I already had like 7 likes. Psh, yeah, me too, Miss Glow. I'm so happy you're here. No, guys, you have to make me work for it. You have to make me work for it. You have to keep me honest. I could just throw anything up from now on. Eat Thin Mints, Terry. Eat Thin Mints. You're welcome. Yes, it's over, but it was an hour and a half long. Yep, we're done. It's done. It's all done. Sue me. That would be great. So there's this other case um about this gate fence and this gate. And it took up it was all day yesterday, missed yesterday. I got all day today. So that whole thing, one of my whole computers was just for that one gate. So the only stuff I got was from this. I do have another one, but maybe guys, turn your volumes down. I have to find it. Turn your volumes down a little bit for a second because I don't even know if I should try this one. I believe there's good content in here, right? However, I do not believe that anybody in the audience will approve of me playing it or trying it or even attempting it. Here we go. I'm going to play it now. So if you didn't turn your volumes down, that's your fault.
So this courtroom doesn't have a jury box or a witness stand, so that means it's not on the level or the square, sir.
Okay.
It's a triangle courtroom.
All right, well, thanks for pointing that out. We'll put that on the record. Mr. Lawford, I was going to reset his bonds where they were before he was released on pretrial release.
So I'm thinking I'm thinking that the volume in this courtroom is unacceptable. Unacceptable for my high class viewers. Even though I know that there's some good stuff. Let me see. This clip is, I don't know, 7 hours long. I know there's some good stuff in there. And I also know that I'm not allowed to show it because everybody would be so mad at me. But maybe Fozzie, maybe that's what I'll do, Fozzie. I will I'll see if there's anything in here, put it as a video, and I'll put on the front of the video, "Don't watch this. It has bad audio." Yes. Yes. That I remember yesterday. It was fun trying to get my stream started. It was fun. But yeah, so I'm gonna see if there's anything in here. I'm just gonna post it as a video. And that way, if it's bad audio, you know up front. Yes, they do, Sarah. Oh, I should be doing this. Hold on. Yes, they do, Sarah. They do. All right, guys, court's open. Oh, I still have plenty of time before court's open. I could take a nappy nap, start some laundry, build a fort, rule the world. Yes, that's the defense attorney. Yeah, I have to watch a video on a Lamborghini too. Gotta fit that into my day. Blanket forts. Yes, let's make some blanket forts. No, man. No, no. These kittens would never allow me to do that. Never. They would deny me immediately. I put one blanket up, denied. Denied. They would knock the refrigerator over, even though the blankets are way upstairs. These kittens will never let me do that. No. Anybody want a kitten? They wouldn't let me do that either. What we need a huff and puff and don't let the kittens blow my fort down. I need cement, iron, cement and iron. Poor Melissa doesn't feel good, guys. She needs a kitten. Sarah, I'm sorry. I'm sorry. All right, hold on. I'm just gonna play one more second because I started it. Now I need to know if there's something happening.
50,000 on the robbery and 15 on the battery.
No objection.
I don't know, Fuzzy. Actually, don't know because my son named these 3 kittens, and one is Oxy, but that does not have anything to do with the drug. It means something else, but something from a video game. I don't even know. The other is Cooter, and I don't know why. And the other is something I can't remember. How am I supposed to remember stupid names like that? How? How? Of course I remember Oxy. Yeah, their names are Minecraft chords. Only Fozzie can find them. Hi, Tina. Thanks, Jay. Yeah, I know. I gotta watch that. I gotta oxymoron. Wanker would be a good one. Would be a good one. Maybe I should just find other country insults to call the cats. And everybody else get mad at me when I call the cat. Come here, plant pot. That's a UK insult. Plant pot. Found that out the hard way one day. What a stupid insult. How do you know that's an insult? You want to see crazy pants? Go see the pro say who sues everybody. Bogan. I'm scared if I say some of these things that I'm actually saying a bad word in a different, like, like cake in Puerto Rico Spanish and cake in Mexican Spanish. One of them means what Charlotte just put on there, and then one of them means cake. And you have to be careful who you're talking to because you might say the very wrong thing. And I don't know which it is. I don't know which is which, but anyway, yes, you would. Oh man, you guys gotta hear Carolyn's redneck, her hillbilly redneck accent. It's on point. It's so good. Yeah, I know, but I slept a little bit today. I slept. I slept. I slept. But the thing is, Charlotte, I don't know how to speak French, so if I even tried to pronounce that, menu. Did I say it close? Menu. English it up for me so I can say it. Thanks, Erica. Thank you. All right, guys, take this chat over to the Discord, and I will see you again soon. Tomorrow, because we have Fleischer today. En français. I speak French. Crème brûlée. Cordon bleu. Uh, all right, Fozzie. One day I'm gonna get paid for it. One day. Bye, guys. Bye, guys. Thanks for coming out. Behave. French fries. Bye, guys.